Good afternoon to everybody. Thank you very much. Thank you very much for coming, for dedicating your lunch break to this lecture, which is part of our lecture series on women, peace, and security. It is a particular pleasure and honor for us to have today as our keynote speaker Navi Pillay. That needs no introduction. She is, of course, the High Commissioner for Human Rights, and she has done a terrific job and continues doing a terrific job in carrying out that office. At the same time, nobody is better placed than her to talk about this topic today. She has, of course, chosen the topic of accountability herself, and dates, I think, her back to her previous incarnation as a judge on the International Criminal Court, for which she has continued being an outstanding advocate after she moved over to the office for the High Commissioner. And last but not least, I think there is nobody better to illustrate the leading role of women in international politics than Navi. So it's really wonderful to have you here. Navi, over to you, and welcome.
Thank you very much, Ambassador, for inviting me. And let me say how pleased I am. I wondered who would sacrifice the lunch hour to listen to a topic as serious as this. Now, I've chosen accountability for crimes against women and girls in times of conflict and instability because I would identify that as the one big challenge my office faces. Because this is where we call for accountability on the part of governments, whose primary responsibility it is to protect and promote human rights of everyone, including women. And so I look forward, I'll speak for about 20 minutes, and then I look forward to the exchange, because I look to you to give me suggestions, strategies, and courses of action we can continue to take to get greater accountability. I would say that there is now overwhelming evidence that conflicts exacerbate pre-existing gender discrimination and put women and girls at heightened risk of sexual, physical, and psychological violence. And one appalling example of this evidence is the report last month of the Human Rights Council's Syria Commission, the International Commission of Inquiry on Syria, which highlights the threat and use of sexual violence in this terrible ongoing conflict, and the vulnerability of women and girls in refugee camps as well to sexual exploitation, forced marriage, and trafficking. So, of course, we all agree it's essential to promote accountability for war crimes suffered by women and girls. Without accountability, women's human rights will be denied. Violence against women will become normalized, and it will spread, denying enjoyment of any woman's rights, smothering all hopes of sustainable peace and development. If I look back, from time immemorial, women were abused in conflict and wars. No one was ever prosecuted until the 1997 Akayesu decision in the Rwandan tribunal. That's the very first investigation and prosecution. I have seen many military manuals, even in this country, which promoted the exploitation of women as a trophy for the soldiers. So you go in there, you fight well, you get all these rewards. So to ensure accountability and deliver justice, remedies, and reparations for the harm that women and girls have suffered, we need transitional justice, a process expressing society's desire to rebuild social trust, repair a fractured justice system, and build a democratic system of governance. Transitional justice encompasses measures to impose adequate sanctions on perpetrators, ensures remedies for survivors, addresses impunity for past crimes, and avoid the repetition of violations. The processes, norms, and structures of transitional justice must be built on the fundamental principles of equality and non-discrimination, and they must fully take into account women's and girls' narratives, feelings, and experiences. Now, we work a great deal on transitional justice in very many areas. You can imagine Mali right now, Libya, Afghanistan, where I've been recently. And what I've just said to you now is barely considered when peace negotiations or transitional justice systems are worked out. And so I see a recurrence of violations in Afghanistan, for example. So let me then go through some of these elements, starting with criminal prosecution. Both treaty and customary international law imposes a duty to prosecute serious violations of international humanitarian or human rights law. Yet, far too many women who have been victims of serious crimes, for them, prospects of having the perpetrators brought to justice are very remote. Estimates of the number of women raped during the war in Bosnia and Herzegovina range from 20,000 to 50,000. However, only a few dozen perpetrators have been convicted by the local courts and the International Criminal Tribunal for former Yugoslavia. In countries like Colombia, Cote d'Ivoire, the Democratic Republic of Congo, Kosovo, Nepal, and Liberia, to name a few, the number of convictions for cases of sexual and gender-based crimes, which mainly affect women, remains very low. All over the world, women continue to face substantive and procedural obstacles in their pursuit of justice. In countries emerging from conflict and instability, these obstacles to judicial accountability can be made worse by a highly politicized and often polarized environment and weakened judicial institutions that lack the necessary capacity and technical ability to investigate and prosecute complex crimes which often involve multiple victims and perpetrators. However, efforts to strengthen the capacities of the justice system have shown positive results in some countries. For example, in the Democratic Republic of Congo, the Joint Human Rights Office of MONUSCO supports legal clinics that represent victims of sexual violence. The Joint Human Rights Office also trains police, prosecutors, and magistrates to better handle sexual violence investigations and trials. As a result of these and other efforts, such as the DRC's innovative mobile gender courts, more convictions have been registered. On the other hand, the prosecution of high-ranking officers, with a few exceptions, has remained a challenge. The lack of prosecution can be difficult and complex, and we need leadership as well as resources. We must ensure that the judicial institutions have the required capacity, resources, and authority. In the DRC, as well as other countries, insecurity, absence of appropriate financial resources, piecemeal interventions, and a lack of political will to prioritize comprehensive structural reforms continue to represent major obstacles to judicial accountability. It is clear that justice should be achieved through national processes first. However, when states are unwilling or unable to ensure accountability at the national level, then international justice should come into play. In recent years, international tribunals have played an immensely useful role in advancing international recognition for gender-based crimes. Both the International Criminal Tribunal for former Yugoslavia and the International Criminal Tribunal for Rwanda have recognized sexual violence, including rape, as acts of torture. and as crimes against humanity. Sexual and gender-based crimes have reportedly been committed in all 8 situations under consideration by the ICC. These are Central African Republic, Cote d'Ivoire, the Darfur region of Sudan, Democratic Republic of Congo, Kenya, Libya, Mali, and Uganda. And over half of the individuals indicted are charged with sexual and gender-based crimes. So this indicates a very positive trend towards a greater recognition of women's experience of conflict and repression. And yet I know, as a former judge, that civil society is highly critical of the fact that not enough has been done to investigate gender-based and sexual crimes against women. Sometimes this was attributed to the fact that the UN tribunals themselves employed only men to go and investigate these crimes. And of course, on the ground, women were under various constraints not to be speaking about these matters to male investigators. So you would think that a simple thing like that would occur even to UN investigators. Let me then move on to reparations. Under international law, reparations encompasses a number of measures, including restitution, compensation, satisfaction, rehabilitation, and guarantees of non-repetition. And also notice how I constantly base myself under the international law framework. And who drew up the framework? It's member states. Therefore, I began by saying we must speak in terms of the duty to prosecute on the part of states. And now that reparations, including restitution and guarantees of non-repetition, are all rights under international law. Ensuring that reparations are just and adequate requires a full understanding of the gender dimension of the problem and consequences of the harm suffered. We need also to invest more effort in ensuring that a proper understanding of gender issues shapes the structure and system of reparations operations so as not to exclude, marginalize, or penalize women. Regardless of whether reparations are ordered by courts or are part of an administrative program, a number of general principles and programmatic guidelines for reparations should be kept in mind. So, what are these guidelines? Firstly, it's crucial to have women's genuine and informed participation in designing and delivering reparations. The views of the victims themselves are crucial for determining what forms of reparation are best suited to their situations. Ensuring meaningful participation requires an investment of time and resources to reach out to victims and overcome barriers like the risk of exposure or retaliation and related stigma, poverty, and the physical and mental health consequences of the violence suffered. My office has undertaken consultations with survivors and produced recommendations to inform reparation efforts in the DRC, in Uganda, and in Kosovo. The second point is that reparations should be guided by the imperative to ensure an adequate and gender-sensitive assessment of the harm suffered. For instance, in DRC, women noted that apart from the physical and psychological consequences of sexual violence, they had also been stigmatized and ostracized from their families and communities, had lost access to their livelihoods, had become the sole breadwinner, and faced enormous difficulties in providing for themselves and their children. I sent a panel out to the remote parts of the DRC 2 years ago, headed by the former Deputy High Commissioner. And when they were consulting the women about reparations, the women said, please don't give us any money, don't give us any things, because we will be attacked. So they were thinking in terms of education for their children and their health, access to health as their main concerns. In Kosovo, victims there also asked for medical and psychological care, financial compensation, additional monetary support to assist with the education of their children, and an official declaration aimed at restoring their dignity and reputation. This is also my experience with survivors and victims whom I recently talked with in Sri Lanka. There is great need for psychosocial support, and NGOs were providing this, but the government stopped it. And I've never seen a more traumatized, weeping people as I did there. So you can see how they identify their most immediate needs. Now, the third factor is that reparations should be guided by the desire to transform the structural conditions within society that allowed the violence to happen in the first place. Priority should therefore be given to reparations that can help enhance women's autonomy and offer opportunities that are traditionally denied to them, such as meaningful employment, education, skills training, and title deed and access to land. Guarantees of non-repetition offer great potential for transforming gender relations. The fourth factor, in deciding the forms of reparations, one must take into account existing obstacles and challenges that women face in their ability to own land or receive and manage money, or even to be able to open a bank account. Finally, reparation processes should be inclusive, involving conscientious effort to avoid directly or indirectly marginalizing women. The process should allow women and girls to come forward when they are ready. Eligibility standards should ensure inclusiveness. For example, documentation required for restitution should take into account greater difficulties faced by women in proving title to property. And of course, for their part, states must acknowledge responsibility for human rights violations and use their financial and institutional capacity in a diligent way to repair the harm suffered by victims. Where political will exists but capacity is lacking or limited, external actors also have a role to play, including through assistance for the design and implementation of reparation programs. In Eastern DRC, for instance, my office has implemented 5 pilot initiatives. Through grants provided to local organizations, victims have been provided with, among other things, psychosocial assistance, medical insurance, payment of school fees, training and coaching for the creation and management of small businesses and economic kits. You see, so these were in response to the survey we conducted amongst women, so they identified what it is they needed. There were a number of women, for instance, who were unable to take their vegetables to the marketplace, and all they needed was a little boat. So we raised funds to get them a little boat. That was their priority. Now, so these pilot projects are intended to inform and inspire the establishment of comprehensive reparation programs for all victims. Jointly with UN Women, we are producing a guidance note on reparations for victims of conflict-related sexual violence, which should, I believe, further promote progress in this area. Let me say a word now about the right to truth. There is growing recognition that efforts to uncover the truth about past human rights violations must be fully gender sensitive. In more and more countries, the mandates, composition, and modus operandi of truth and reconciliation commissions and similar bodies are increasingly designed and operationalized so as to ensure that women and girls' experiences are taken into account. Now, as you know, in South Africa, we had Archbishop Desmond Tutu chair the Truth and Reconciliation Commission, and we once shared a podium, the Arch, and we call him the Arch here, and he was promoting the idea of Truth and Reconciliation Commission, how inexpensive it is, instead of justice and prosecution. And I was judge from the Rwanda Tribunal, and I leaned towards him and I said, now you've almost convinced me. And he said, no, you have to get on with what you are doing as well. So you need both components. Now I, trained in the legal system as some of you are here, find that the courts are not there to seek the truth. They're there to render justice. The truth doesn't always come out. The historical truth on what happened and what was the situation before. And now I fully understand, as I hear more and more women's voices asking for the right to truth. Reports from the Truth and Reconciliation Commissions in Sierra Leone, Timor-Leste, Peru, and Guatemala have all explicitly acknowledged the serious harm women and girls suffered from conflict-related sexual violence. The recently published report of the Kenya Commission also includes a chapter on sexual violence as well as gender-specific recommendations. So I have to concede as a judge all my lifetime that we wouldn't achieve that in the courtroom. So although you need prosecution and justice, you need this kind of truth-seeking measures which people seek. 4 United Nations supported truth commissions are ongoing now. You may know of them: Kenya, Cote d'Ivoire, Brazil, and Mali. 2 of them, Kenya and Brazil, have internal gender mechanisms. The percentage of women's representation amongst commissioners has also grown in some cases, although overall we are far from achieving equal gender representation on the commissions. Now, as with reparations, Truth and Reconciliation Commissions must make specific efforts to encourage and facilitate women's full and meaningful participation. And such measures must take into account all procedural factors that may hinder or discourage participation, such as lack of measures to protect confidentiality, poverty, illiteracy, mobility limitations, and relevant cultural and societal norms. For instance, the South African Truth and Reconciliation Commission found that women downplayed or remained silent about their own suffering, particularly sexual violence. It then decided to take special steps to encourage women to testify, including holding 3 special women's hearings. In its final report, the Commission wrote, I quote, "These hearings brought to light the particularly gendered ways in which women experience human rights violations." Commissions of inquiry are also crucial bodies to investigate serious violations of women's rights. Different arrangements have been put in place to provide different commissions of inquiry expertise on sexual and gender-based violence and gender integration. Rapid deployment fact-finding missions are investigating violations of international human rights law and humanitarian law. And I'm really pleased that my office, which supports international commissions of inquiry, has right now Syria and the Democratic Republic of North Korea, that we have been able to provide experts on sexual and gender-based violence in situations such as Guinea, Conakry, Cote d'Ivoire, Libya, and Syria, partly also thanks to our promising collaboration with UN Women. And I should say as well now the SRSG on sexual violence. There is, however, a need to strengthen the capabilities of all these bodies to address the impact of conflict on gender issues and to measure fully the interdependence and interrelatedness of all human rights violations that occurred during conflict. My office is undertaking an internal lessons learned experience on the provision of SGBV expertise to commissions of inquiry at the end of October. And we will undertake a broader assessment of gender integration into the work of commissions of inquiry in 2014. These exercises will inform our future efforts in this direction. I may move on now to guarantees of non-recurrence and institutional reform. In the aftermath of conflict, as states and international actors are reforming the security sector, they should take the opportunity to strengthen the transparency, accountability and professionalism of the security apparatus and to make it more gender aware. Doing so enables women to have greater access to justice and strengthens accountability for gender-based crimes. Security sector reform should include efforts to remove gender biases and strengthen the capacity of security sector actors to understand and respond to specific security threats for women. Internal and external oversight may be needed to increase institutional accountability on gender. Security sector reform can also provide an opportunity to ensure that there are enough women in the security forces, which, quite apart from creating jobs, encourages higher rates of reporting of incidents of gender-based violence and improves gender-sensitive treatment of female witnesses, victims, and suspects. The disarmament, demobilization, and reintegration, DDR, of former armed combatants, which often follows a peace agreement, is also closely linked to security sector reform. Former combatants are often encouraged to transition into security forces. Vetting ex-combatants applying for security jobs should include appropriate checks to disqualify known perpetrators of sexual and gender-based violence. This alone can offer some satisfaction to victims who cannot achieve a prosecution or a conviction. If this is not done, and if these perpetrators are placed in positions of authority, this humiliates victims, endangers them, and sends the message that violence against women is socially acceptable, discourages victims from coming forward, and it can also expose women and girls to violence. In this respect, I am pleased that the UN has adopted and is implementing a policy to screen its personnel to ensure that they are not implicated in human rights violations. It's called the Secretary General's due diligence policy. I also believe that according to the spirit and letter of CEDAW and other human rights instruments, approaches to non-recurrence must be framed in states' obligations to address structural and systemic gender inequality and discrimination through comprehensive legislative policy and institutional reforms. And since I just mentioned CEDAW, let me direct you, you probably all know it, that CEDAW on Friday, 18th October, adopted General Recommendation number 30 on women in conflict prevention, conflict, and post-conflict situations. Quite a thick document, very, very important. I was just skipping through it, and I see in the preamble, paragraph 6, they say women are not a homogeneous group, and their experiences of conflict and specific needs in post-conflict contexts are diverse. women are not passive bystanders or only victims or targets. They have historically and continue to have a role as combatants, as part of organized civil society, human rights defenders, members of resistance movements, and as active agents in both formal and informal peace building and recovery processes. States parties must address all aspects of their obligations under the Convention to eliminate discrimination against women. So I do recommend that we all look at this. And there's even an injunction to the Security Council to ensure that the implementation of Security Council commitments reflects a model of substantive equality and takes into account the impact of conflict and post-conflict contexts on all rights enshrined in the Convention, in addition to those violations concerning conflict-related gender-based violence, including sexual violence. So, back to where I was, I would say that developments in the MENA region exemplify the need for transitional justice processes and institutional reforms that are mindful of the interdependence and interrelatedness of human rights. In some countries in this region, women parliamentarians face fierce opposition when they propose laws that address women's rights, while in others, women's public space is shrinking due to threats and intimidation. So it's crucial that while we look into quotas and other mechanisms to support women's participation in political systems of countries emerging from conflict, that we also consider how illiteracy, poverty, discrimination, and violence conspire to prevent their effective participation. So let me conclude by stressing that accountability for crimes against women in times of conflict and instability must be pursued through gender-sensitive transitional justice processes which address perpetrators' impunity and promote women's access to justice, adequately recognize and consider women and girls' experiences in efforts to uncover the truth, and promote the design and delivery of gender-sensitive and comprehensive reparation programs. Preventing recurrence of violations against women and girls further requires seizing the opportunity that societies emerging from conflict and instability present to develop and institutionalize legislative, policy, and other measures to advance women's human rights and to overcome deeply rooted patriarchal customs and norms. I speak with some positive sense there because that's a chance we had in South Africa. Coming out of a highly unstable situation, we used it to put all our rights into the Constitution, such as the right to equality and the right to sexual orientation. So really, all of you contributed to make sure that we put in the highest standards in our Constitution. As I look around now, I see that it's actually absent in constitutions of many countries. You don't even have the ERA here in the United States, for instance. Now, so in all cases then, we need genuine commitment by states, working in collaboration with civil society. I always say none of these advances have happened because governments woke up one day and said we want to be more accountable. That's not the way it happened. It happened because civil society pushed for accountability, to tackle all of the above in order to ensure that accountability to women and girls is achieved. So thank you very much. I might have gone a little beyond 20 minutes. Is that all right?
No, it's really all right. Thank you very much, Nadia, for a very, very rich talk. And I will be happy to turn it over to the room in a minute. But if you don't mind, perhaps I ask the first question. On the judicial side, so we've talked about the Akayesu trial, and the advances in international criminal justice, the work of the ICC, the focus of the Office of the Prosecutor has on gender-based crimes. I think 14 of the persons indicted before the court are charged with gender-based crimes. But at the same time, we don't really see a significant decrease of sexual violence on the ground. What, how do we make sense of that? I mean, what is it with the preventive effect, the deterrent effect that we always like talking about? Is there something that is missing in what we are doing and what the courts are doing, or how do you explain that?
Well, I would say that courts, and particularly the international courts, can only play a limited role. Firstly, they prosecute only those who are most responsible, where the sexual violence is done on the ground by, say, ordinary troops or soldiers. So very often those charges don't appear in, say, the ICC indictment, unless you can, the prosecutor can establish orders granted or failure to take any action to prevent, so that you have to establish that link. So this is why, even though my voice is for justice, I stated the limitations of prosecutions, urged that we do much more in transitional justice processes to put protections in place in the legal system, and also to hold a dialogue on all these matters. Otherwise, there's a denial that sexual violence against women even takes place in times of conflict and instability. I even know that when we were busy with Libya, there were 2 points of view on the part of investigators. I think it was the SRSG who announced that there was sexual violence going on in Libya, but the head of the Libyan Commission of Inquiry that we service, Sharif Bassioni, said that he had found no such evidence. So that's why I very carefully place before you the risks about who does the investigation and how carefully you have to be sensitive to the women, whether they're in detention or they're living in societies where they face even worse repercussions if they speak out on gender violence to which they were subjected to. So I would say, apart from prosecution, all of us have a role to play in bringing these issues out and ensuring that women have the power and security to speak about what has happened to them.
Thank you very much, Nabi. The floor is open for your questions and comments. Please identify yourself, because I don't know everybody in the room. Thank you.
Yes, hello. My name is Jean Krasno, and I teach at Yale University and the City College of New York, and I teach courses on the UN. I had a couple of questions, and I'll be really quick. One is, what is your opinion on universal jurisdiction? And I'm referring now to the Belgian case before the ICJ against Senegal for the extradition of the former president of Chad. And then the other question is your opinion or your view of the complexity of the use of force. For example, the intervention brigade that is now been deployed in the DRC, and how one should think about the use of force in protecting women.
Thank you. Perhaps another one? I think there was somebody else here. No?
Just a second.
Yes, please.
Hi, this is Asaq Shaheen from United Arab Emirates. I'd like first to thank you very much. You're amazing. So basically, I'd like to share my thoughts. So we can approach this through legislations, education awareness, preventive measures, empowerment of women and girls. Yet to hold individuals, and yet what's more important is to actually hold individuals and entities accountable. And what's more important is to hold the government actually. Thank you.
Thank you very much. Perhaps a third one, and then we go back to the High Commissioner. Yes, please.
Thank you very much, High Commissioner. My name is Kristen Broker. I work with Jacob Blaustein Institute for the Advancement of Human Rights. Really appreciated your comments, and this question sort of piggybacks on what Ambassador Wennemeister already mentioned, which was the impressive overview you gave of the progress of international accountability for sexual violence. And my question is, do you see this as coming under challenge, particularly in recent weeks? And how do we maintain the momentum for international accountability for sexual violence? I'm thinking particularly in the wake of the African Union's decision regarding heads of state at the ICC, but just more broadly as well. Thank you.
Thank you very much.
These are all great questions, and I really wish I was in your class, Jean, if you're discussing these matters. And also, thank you, Asak, for the compliment. Let me tell you that when I was your age, I had very little patience, because this is the way the young lawyers are trained. So I would listen to the women and feel they're just so weak, you know, why don't they just get on with it and deal with it? Until I started listening to them, and they said, we've come to you because you will understand the woman's perspective. So it's just a lifetime of learning from everyone, and just feeling deep empathy, because you now have some power to do something, even the power to articulate, because the victims feel all deep emotion and they cannot articulate for themselves what it is they seek from government. So both Jean and Asaf made the point about holding governments accountable, which is what universal jurisdiction is about. International law is clear. Where a state manifestly fails to protect its own citizens, then there is a duty on the part of the international community to intervene. And this is what we've been saying again and again in respect of conflict areas where governments are either responsible for failing to protect or themselves responsible for the violations, or are unable to act, for instance, against rebel leaders. And therefore, the world recognizes this very important principle of universal jurisdiction. You know, I come from the continent of Africa. There was no such thing as a mechanism for accountability. There was no such thing as the international criminal justice system. As you know, right from Nuremberg, there's been nothing. And we often saw dictators who committed great crimes in Africa being sheltered, as we used to say, on the French Riviera. I think some are in Saudi Arabia as well now. And we sort of hungered for some state to take action and prosecute them. Belgium, of course, asked for the extradition of the president of Chad, former president of Chad, who's been, I think, almost 8 to 10 years in Senegal. I have raised a very strong voice for Senegal to get on with the national prosecution, even saying to the former president, well, here's the opportunity. Africa always saying it can do it on its own. Well, now do it. They were asking for funding from Europe. This funding was provided, but it was my view, and I said so to the president, you have judges here and you have courtrooms. What are you waiting for? The AU had directed Senegal to proceed with the prosecution of Hissène Habré, the leader of Chad. So there you are, a regional body to which they belong, also directing them to prosecute. So I see now that soon after President Obama's visit and some funding provided to Senegal, they finally have placed Hissène Habré in custody and getting on with the trial. So at some stage, in some part of this time, Belgium, the lawyers and civil society activists in Belgium initiated a number of national prosecutions until Belgian government stepped in and curtailed those prosecutions. It became very embarrassing for them when there were indictments against Bush and Rumsfeld, that kind of thing. And similarly with the Spanish prosecutor in Spain, who was reined in as well because he was proceeding with universal jurisdiction. But I tell you, the world's victims who have no remedies for justice in their own national courts or in their regional systems, since SADC tribunal has been rendered dysfunctional by the SADC countries, for instance. So where victims don't have remedies in their national systems, then there should be willingness on the part of countries to exercise universal jurisdiction. I think someone is being tried in the UK mostly, exercising universal jurisdiction. It will come back to me. So therefore I agree with you, it's very important to hold governments responsible because they've been elected to serve the people, they have the resources and the power. We need greater political will for them to take responsibility. The difficulty for the United Nations is when the violations are attributable directly to the authorities who are in control. It's very, very difficult to get cooperation. Tribunals also, I mean, the ICC will have difficulty getting the cooperation of states to secure arrests, such as on the indictment of President Bashir of Sudan, for instance. Which really brings me to your question there, Christian, on all of you would have followed that the African Union met in an extraordinary session on the 11th of October, and they passed a resolution asking for the Security Council to defer the trials of the Kenyan president and vice president. But in the course of it, they made a statement which is of concern. And the statement is that heads of state and certain figures in authority are immune from prosecution during the tenure of their office. So now, what do you think of that? What we have in law is that most states have the provision that the head of state or certain figures in government are immune from prosecution while they're in office. Now this relates to domestic jurisdiction. It also relates to, say, one head of state asserting this immunity against another state. So you can't prosecute me, I'm the head of state here. But it's for domestic cases. It is not for international crimes. International law is clear that you cannot have immunity for international crimes. You have the ICJ judgment on this, you have the Rome Statute on this. And therefore I think that statement is of concern, and I said so in my address before the AU at the observance of their 60th anniversary last week in Geneva.
Thank you very much, Navi. The floor is open. Yes.
Hi, my name is Brett McAvoy with the NGO Working Group on Women, Peace and Security. Thank you, Ms. High Commissioner, for your comments. I wanted to return for a second to the comment about the limitations of prosecutions, and specifically to use the Special Rapporteur Pablo Dubrev's term about coherence amongst the various transitional justice mechanisms, whether we need to place a greater emphasis on reparative justice, and whether that means less of an emphasis on prosecutions given a world of finite resources. Think of the Special Court for Sierra Leone having spent approximately $250 million over its tenure versus, I believe, what is about 2 to 3% of that value that's been spent on reparations for survivors. If you could just comment on that incoherence between the two mechanisms. Thank you.
Thank you very much.
Yeah. Yes, please. Thank you very much. Kutlay from Turkish Mission. Justice Counselor. Let me thank first Liechtenstein Mission and these mutual organizations for holding this special panel. And I would like to also appreciate Madam Nevi for her impressive presentation. What I want to do is just to make a few brief comments on some of the necessary justice sector steps for enhancing criminal accountability and stopping conflict-related sexual violence. And I would like to put a question to Madam Navi in this context. The key point I would like to make about the justice sector and judicial machineries in transitions is that the strengthening investigative capacity of national judicial actors is a significant law enforcement tool to provide especially an efficient and successful investigation for the countries in conflict. Moreover, efficient and successful investigation must be capable of leading to the identification and punishment of those responsible for sexual violence. So what I am trying to say, yes, an investigation must be launched, but also this investigation must be successful. It should get some kind of positive results. Therefore, it seems to me very obvious that enhancing criminal justice systems' responsiveness to conflict-related sexual violence through effectively functioning justice sector machineries is the cornerstone of the promotion of the zero tolerance. So, and in this context, justice sector institutions should be accorded an effective legal policy and institutional framework that not only criminalizes such a gross violation in legislation, but also punish perpetrators in practice. That brings me to the end of my comments. And in this context, what I would like to ask to Madam Nevi is that I am wondering your position on what kind of special support should be given by the international community under the framework of the United Nations, especially to the conflict or crisis-affected countries in making investigative system work properly. Thank you very much.
Thank you. There's one more for this round. Yes, please.
Asif Khan, the United Nations Foundation Women and Girls Team. I was just wondering, gender-based violence, the purview of violence against young boys and men, is that gender-based violence as well? If so, the reporting levels are much, much lower than women. The stigma attached to being raped when you're a male by a male. Just wondering your position on that, your thoughts, and anything you've sort of learned from the long years on that topic.
Many thanks. Now we go with you.
Well, the first question related to the coherence of transitional justice system. Whether we can have rapid prosecutions or less prosecutions. This is why I mentioned the Archbishop Desmond Tutu and myself, because what he was highlighting is the cost. Justice is very costly all over the world, including the international tribunals. But no country in the world has abandoned the concept of the national justice system just because it's expensive. It's expensive to investigate, it's expensive to keep people in prisons. So I am very familiar with the Special Court for Sierra Leone and the transitional justice system that went on under Bill Shabazz at the same time. And we always thought that was ideal, to have both the criminal justice system and the truth-seeking mechanism. So, and so therefore we were interested in the pros and cons about whether that was a success. And I think that that's the first and only time where we had both systems together. And so at the time I was also in the court system, so I was familiar, for instance, with the tension. The president of the Sierra Leone court wouldn't allow certain of the accused people to go and give evidence in the truth TRC, and Bill Shabazz was complaining to me that that's not proper. They have a right to come before the Truth Commission. So there are those tensions. But with regard to costs, I think that both are necessary. This is the point I was making, that when you listen to people, they want the truth. I've heard many say, I want to know where's the bones of my son, so I could say a proper farewell. Which brings me to the next point you made. I think it's appalling. I agree with you. Sorry, Christian kept on 2 to 3% in the case of Sierra Leone for reparations. Well, no reparations in the two ad hoc tribunals set up by the Security Council. That's ICTR and ICTY. And we soon realized, sitting there, that that was a massive failure. We let down the people of Rwanda. We were using them as witnesses, having to retell something that's happened like sometimes 10 years earlier, requiring them to relive all this. And I received many reports of these witnesses after they testified, living in terrible conditions with no medical help and so on. And they often raise the question of reparations to us judges. We then wrote to the Security Council, and with all judges signing that document, asking the Security Council to provide reparation for the ICTR and ICTY. And it's because of those efforts that we pushed for it in the ICC. So there you have a trust fund for victims. So I agree with your point. It's skewed justice for victims if you only provide prosecution and then look after the perpetrators. The thing that I used to hear all the time in Arusha, in that tribunal where I was the president, is the UN is spending money to provide AIDS medication, antiretroviral medication to detainees. I don't know how they knew that, it's supposed to be confidential. But we're providing that, but not for the victims of these perpetrators in Rwanda. So I have no answer for that. But so thank you for your important point. Obviously you have to have an independent, well-resourced judicial system with qualified investigators and judicial officers and protection of witnesses. It's just some total of a comprehensive justice system. And we are very committed to providing training for both judges and for investigators, especially for sexual offenses. It needs a particular sensitivity. So my office does do training together with other UN agencies. Particularly pertinent area is Libya now, where the ICC has, the pretrial chamber in ICC has permitted Libya to carry out national trial of Sanusi. Well, firstly, the ICC has indicted Sanusi?
Yeah.
Well, then he's not in their custody, but in custody of Libyan authorities. So no objection to them holding the trial, but obviously all of us, plus the ICC, will watch whether it's a fair trial in terms of international standards, whether the investigators are well qualified. And so we have 8 or more human rights officers in the UN mission doing exactly this, trying to strengthen the judicial process, providing training. But there's a lot of work to be done there, I would say. Gender-based violence against boys and men. The world was shocked when evidence of boys and men being subject to rape and sexual violence in former Yugoslavia. Let me say that the indictments in the ICTY spoke of sexual violence and not rape, because there was no common definition of rape under international law. So ICTR, where I sat, then created a gender-neutral definition, and which definition was then adopted by the ICTY when they found acts of rape against perpetrators, rape and sexual violence of boys and men. The South African Constitutional Court found itself determining the penalties subscribed where a child victim is a girl, in which case a very severe penalty. And when it's a boy, then it was, I think, a minimum of 3 years or something, which troubled the local magistrate who found that the victim, in this case, whether it's a boy or girl, they suffer the same as a result of the act. So therefore, there's something wrong in these penalties, which are really old traditional laws that we inherited. It went before the Constitutional Court, and I'm happy to say that they referred to the gender-neutral definition of the Akayesu trial in order to order the government to change the law so that the victims are treated equally. So when we speak about gender-based violence, this is what we cover: people who have been violated on the basis of their gender and sex.
Many thanks, Novi. Abigail, you have a question?
Thank you, High Commissioner, for sharing your thoughts with us on this important issue today, especially in your focus on the importance of a process that ensures women's full participation in the mechanisms holding states accountable. And thank you to the Mission of Liechtenstein and Princeton Liechtenstein Institute for Self-Determination for continuing this really important lecture series that is incredibly popular. I think draws more people every single time. You're going to have to look for bigger rooms. As an international group that has been working for an integrated approach to peace and security for almost 100 years, the Women's International League for Peace and Freedom believes that meaningful change is only possible by coordinated action that strengthens women's voices and participation and breaks down silos across different areas, including women's human rights, women, peace and security, and disarmament fora. This year, we've been working to strengthen that integrated approach throughout the UN system, including through successfully advocating to include a gender criterion in the Arms Trade Treaty and to address 1325 implementation outside of the Security Council as well as in it, such as through the Human Rights Council's Universal Periodic Reviews of Colombia, the CEDAW Committee's recommendation for the DRC, and also pushing in this recent resolution on Friday to recognize the importance of respecting and ensuring human rights for all on this resolution. As such, we particularly welcome you being here with us today, as well as for your expertise in addressing these issues. There still are major obstacles, of course, that continue, especially in the institutional gaps between, on one hand, human rights and development, and on the other hand, security. And my question for you is, what key opportunities do you see to strengthen the political will for an integrated approach to security that increases state accountability for their human rights obligations? On Friday, the most recent resolution actually recognized state obligation to respect and ensure human rights, which is, I think, a really good step forward. But how can we build on this momentum, and in particular, recognize state obligations to respect, protect, and ensure women's equal human rights without discrimination or retrogression, as per the Maastricht Guidelines of the International Covenant on Economic, Social, and Cultural Rights, in more areas? Thank you again for all your work and for being here. We look forward to continuing to work with you on these issues.
Thank you very much. Floor is open. Yes, please.
Thank you very much, High Commissioner. Just very quickly, you spoke about the current commissions of inquiry regarding the DPRK in Syria. I was wondering if you had any insights into specifically the gender perspectives that have been used in those commissions, or any conclusions thereof. And then very quickly, if you could discuss how this concept of traditional values, which has been promoted by some state delegations, may interplay with efforts to ensure accountability in transitional justice.
Thank you very much. Yes, please.
Thank you for giving opportunity to speak for a few minutes. I know we don't have enough time now. Especially, Madam Commissioner, I know you very recently visited in Sri Lanka, and then you have experienced post-conflict situation in Sri Lanka. So, but today, my name is Upati Chakma. I am representing actually the Chittagong Hill Tracts from Bangladesh. So we had a same experience in Bangladesh, but it's still going on. We had a peace agreement between the government and Chittagong Hill Tracts people, 1997. So as you mentioned also, your experience in Sri Lanka. So we have also not only for the gender-based like women or girls, but being indigenous people and being minority in Chittagong Hill Tracts. You know, Bangladesh is a Muslim majority country. So our women and girls being indigenous, being minority, we are more oppression then, because they say some religious extremists working in Chittagong Hill Tracts, they say if you are non-Muslim, so no matter if you rape or kill to the indigenous women or girls. So this year, the Chittagong Hill Tracts Commission made executive summary violence against women and girls in Chittagong Hill Tracts. And so my question is, Madam Commissioner, we always have the same experience, something against women and girls in Chittagong Hill Tracts, but we never find any justice from under the Bangladesh Constitution or under the Bangladesh law. So if we cannot get justice, or we cannot find justice in the country, how can we, where we have to apply or where we have to go to asking for justice for justice for our women and girls? Thank you for your time.
Thank you very much. Very interesting questions.
Well, the first question was yours, Abigail, on political will and how to get states to carry out their obligations. I would say that a great deal has happened in the past 20 years that was not there before. A permanent court for international criminal justice. Leaders saying that if they fail to protect human rights, which then leads to serious crimes, that they can be held accountable. You see, we never had this. We never had 1325 resolution before Security Council, which most of you promoted, and that's how we had it for the very first time. That the Security Council dealt squarely with the issue of gender violence. Now, all these steps, including what's going on in the Human Rights Council. Human Rights Council, a subsidiary of the General Assembly, is, I believe, the body now that is ensuring implementation of the Universal Declaration of Human Rights, getting states to be more accountable. And one of the ways is the Universal Periodic Review, UPR, which I bet most of you are familiar with. It's webcast, 193 countries, that's all the member states were reviewed in the UPR. In other words, their human rights record are reviewed by their peers, by other states. They don't just criticize, they make recommendations. And almost always there's a recommendation on accountability for serious crimes, justice for victims. So these recommendations come from other states. Now they've started the second 4-year review. So about 80 states have now undergone their second review, in which, in this case, they have to come and tell the world body on how they're implementing these recommendations. And very, very often comes the request to us to help, to provide human rights advisors, to provide training. So I see all these as at least not only to secure accountability, but to get governments to change. We want the protection, we want the prevention of human rights violations. So I see the level of the dialogue, I see the level of civil society organizations' awareness, particularly of youth, and because of the social media, they're able to articulate and claim their rights now, things that never happened before. And when people go out onto the streets and protest or claim their rights in large numbers, change happens. Governments have to listen to that. It's happening right now in Egypt, for instance. In Paris, there are school children who are on the streets blocking entrance to high schools because they're so offended by the fact that this 13-year-old was stopped and taken off a bus by French police because they deemed that she and her family were Roma. She comes from Kosovo, I think. So I see not only the United Nations having established mechanisms for accountability, but civil society, especially the young, just so aware of their rights. You know, my grandson is 6 years old, and he said to me, "Why are you calling me boy? My name is Senthil." So they know their rights now. The clash or the excuse of traditions. This is our culture, this is our tradition. I see every day of my life. We can't change things too fast because the people are not with us. It's a response for death penalty, for instance. It's a response when I raise issues like witchcraft. I went to a country, there was a 10-year-old woman, it's always women, who are accused of being witches and imprisoned. And the government said to me, but this is the tradition. FGM is a tradition. Smoking was a tradition, but we've managed to tackle that. So I come out very strongly about any tradition that is harmful, imposed on people, and I come out strongly on the need for governments to take the lead. They have to provide the leadership to end harmful traditional practices, such as flogging of women. There was a very strange case of a young woman who was raped in Maldives, a young girl, I should say, was raped, but the traditional court sentenced her to public flogging. And who came to see me about it? 2 women ministers from the government. Although they were in government, they felt helpless to do anything about it. And I said, your president can do something about it. He's got the power. He can stop the flogging. Because I know that the King Abdullah of Saudi Arabia responded. We do a great deal of this, the discreet efforts, because if you can save a life, help a woman, it's worth it. So you don't see that in our public statements, but the quiet, discreet interventions, also by the Secretary General, sometimes are rewarding. So in the case of Saudi Arabia, where the woman was sentenced for driving, not allowed to drive if you're a woman in Saudi Arabia, and she was sentenced to flogging, the king intervened and stopped that flogging. The king of Saudi Arabia, who told me that he has to go slowly, otherwise there's a backlash against them. And I think we have to be sensitive to that as well. That extremist forces will rush forth, as did the Taliban in Pakistan in the case of Malala. So if you can help me also to deal with this excuse of tradition and culture. I went to a Caribbean country and asked them why they beat up their children. And the minister said it's a Caribbean culture. I said it's a 50-year-old British law here. You need to change it. So keep an eye open and let me know how we could address this. It also comes up in death penalty. And Bangladesh, yes, I feel for the people of Chittagong Hill. And this is why I said where many people don't have access to remedies within their countries, and we need to strengthen the regional mechanisms. ASEAN mechanisms have just started. I've gone twice to Bali to encourage that process. So we need to support the principle of individuals being able to take their complaints to a regional court, such as the European Court of Human Rights. So I know it's of no immediate help to you. We're getting there with this. So thank you for your question. Thank you.
Thank you very much, Navi. Great talk, fascinating conversation. Many thanks to you, and many thanks to you for your leadership in particular. And of course, thanks to all of you for coming. We look forward to seeing you next month when we have the next panel as part of our panel series on peace and security. Thank you.